Every workplace has rules, but in India, for a lot of companies, those rules aren't just some handbook you get on your first day. They're actually part of a legally binding workplace constitution. It's a whole framework that governs the relationship between a boss and their team. And today, we're going to break down exactly how it's built, how it can be changed, and what happens when someone breaks the rules.
All right, so let's get into it. How does this whole workplace constitution actually come to life? We're going to follow its entire journey. First up, we'll see how the rulebook gets created and made official. Then we'll look at how it can evolve. We'll also explore a really big idea, shifting from just top-down rules to a genuine partnership. And of course, what happens when things go wrong? We'll dig into what misconduct really means in the eyes of the law, uncover the bedrock principles of fairness that everyone has to follow, and finally, walk through the step-by-step process of a formal investigation that's built to find the truth.
Okay, first things first. How does a company's set of rules become legit? We're not talking about simple HR guidelines here. These are called standing orders. And get this, to stop employers from just making up arbitrary or unfair rules on the spot, the law says they have to go through a formal certification process before any of those rules actually mean anything legally. Now, this might look like a lot of paperwork, but here's the kicker. A really important change happened back in 1956. Before that, the certifying officer basically just checked if all the boxes were ticked. But now, they have to act more like a judge. They have the power to actually decide if the rules are fair or reasonable. That one change completely transformed this from a simple rubber stamp exercise into a real check on an employer's power. It makes sure the Constitution is balanced right from the start. But let's be real, workplaces are constantly changing, right? New technology comes in, business needs shift. So once these standing orders are certified, are they just locked in forever? Nope, not at all. The law has a very clear path for updating the official rulebook. At the same time, the law is designed to prevent total chaos. Once a set of rules gets certified, there's a mandatory 6-month cooling-off period. You can't touch them for 6 months unless, of course, both the employer and the employees agree to a change. It's a smart way to create stability and let the new rules settle in before anyone starts trying to change them again. And what's really fascinating here is the symmetry of the whole thing. The process for changing the rules is almost exactly the same as creating them in the first place. And it doesn't matter who wants the change, the boss or the workers. The proposal goes back to that same certifying officer who uses the very same test of fairness and reasonableness. It ensures that as the rulebook evolves, it stays balanced and fair for everybody involved. Okay, so we've talked about the rules, but Indian industrial law has an even bigger vision. It's not just about commands and obedience. It's about building a real collaborative relationship. This is where this cool concept of workers' participation in management, or WPM, comes in. It's all about shifting the vibe from a master-servant dynamic to a true partnership. And this isn't some new-age corporate jargon, by the way. This idea has really deep roots, inspired by a vision from Mahatma Gandhi way back in 1920. This principle that labor is a partner in the whole project is so important that it was actually written into India's constitution. It's a guiding light for how the country should operate. So, how do you actually make this partnership happen? Well, over the decades, the government has rolled out different schemes, each one a little more ambitious. It started out simply, with works committees just focused on keeping the peace. Then came joint management councils for more serious consultation. By the 70s, you had shop councils getting workers involved in production decisions right on the factory floor. And finally, the biggest plan of all aimed to have this partnership at every single level, right up to a seat in the boardroom. All right, so you've got the rule book, you've got this spirit of partnership, but people are people, and sometimes rules get broken. When that happens, we first need to understand what the law actually considers misconduct. The legal definition, which India got from English law, is pretty broad on purpose. It basically says misconduct is anything that's inconsistent with the faithful discharge of your duties. Think of it like this. It's not just about breaking Rule 7b in the handbook. It's about any action that fundamentally shatters the trust that holds the entire employment relationship together. Now, to make that practical, the official model's standing orders give some clear examples. They group things into categories. So there's a huge difference between, say, being late a few too many times, which might get you a warning, and something like theft or fraud, which could get you fired on the spot. The key idea here is proportionality, right? The punishment has to fit the crime. Okay, but accusing an employee of misconduct is a huge deal. It can literally change their life.
So how does the system make sure that the investigation itself is fundamentally fair? The answer comes down to two ancient but incredibly powerful legal principles.
These are known as the principles of natural justice, and they're the golden rules for any fair process. First, you have the rule against bias. Basically, you can't be the judge in your own case. The decision maker has to be neutral. Second, there's the rule of a fair hearing, which simply means you always have to hear the other side of the story. These aren't just for courtrooms. They apply directly to what happens inside a company's walls.
And when it comes to bias, the courts are unbelievably strict. This landmark case, AK Krypok, set a really high bar. You don't have to prove the decision maker was biased. If there's even a reasonable chance or appearance of bias, the whole decision can be thrown out. It's not just that justice has to be done, it has to be seen to be done. And that second rule, the right to be heard, got a massive boost from the famous Maneka Gandhi case. The Supreme Court said that since a job is how a person makes a living, any process that could take that away must be fair, just, and reasonable. It's a constitutional right. So even if a company's own rules are a bit vague, this core principle of fairness just automatically kicks in. Okay, so we've got these powerful, big picture principles. But what does a fair hearing actually look like on the ground during a real workplace investigation? Let's walk through the formal steps.
When an employee is formally accused of something serious, the employer can't just call them into an office and fire them. They are legally required to conduct what's known as a domestic enquiry. And you can basically think of it as a formal, internal trial designed to figure out what really happened. This whole process is really just hearing the other side in action. It's not a casual chat. You can't defend yourself if you don't even know what you're being accused of, which is why it has to start with a formal charge sheet. You need time to get your story straight, so a reasonable time frame is guaranteed. And crucially, it works like a mini trial. You get to present your evidence, and just as important, you get to challenge the evidence against you by cross-examining witnesses. Finally, the decision can't be based on a gut feeling. It has to be a logical conclusion based only on the evidence presented in that inquiry.
And let me be clear, this isn't just a nice-to-have or good HR practice. It's the law. Decades of court cases, like the big Sir and Namel case, have hammered this home again and again. Employers must hold a fair and just inquiry before they can hand out a serious punishment like firing someone. If they cut corners or run a biased investigation, the courts can and will step in and overturn the whole thing.
So, when you step back and look at the whole picture, from crafting the rules to investigating when they're broken, you see it's all about one thing: balance. It's a delicate balance between an employer's right to run their business and an employee's right to be treated fairly and have job security. And as India moves towards a new industrial relations code, that's the big question on everyone's mind. How do we preserve this essential balance of justice in the fast-paced workplaces of the future?